The term death row evokes a primal fear, a chilling intersection of finality, justice, and the ultimate power of the state. It is a universal concept, yet its application and reality vary drastically across the globe. In Asia, a continent of immense diversity and complex political landscapes, the death penalty is not merely a legal statute. For many, it is a lived nightmare shrouded in opacity and, at times, profound brutality. While global attention often focuses on capital punishment in the United States or the Middle East, the practices within many Asian nations remain obscured behind a thick curtain of state secrecy and political pragmatism. This comprehensive analysis seeks to pull back that curtain, venturing into the grim world of executions in Asia. We will explore not only the harrowing methods employed, but also the psychological torment inflicted upon the condemned, the profound injustices that can lead to irreversible sentences, and the deeply political undercurrents that fuel this ultimate punishment. From the industrial-scale executions in China to the psychological torture of Japan's secret hangings, and from the political theatrics of Indonesian firing squads to the grotesque spectacles of North Korean purges, this journey uncovers the shocking realities that have left the international community both speechless and compelled to demand change. The global context, a decline. Shadowed by secrecy, globally, the trend towards the abolition of the death penalty is unmistakable. According to reports from leading human rights organizations like Amnesty International, a majority of the world's countries have now abolished capital punishment in law or practice. However, this progressive trend casts a starker shadow on the few nations that continue to carry out executions, a group in which several Asian countries feature prominently. While the provided script mentions a specific figure from a previous year, ongoing data reveals a consistent pattern. A handful of nations, including China, Iran, Saudi Arabia, and Egypt, are responsible for the vast majority of known executions worldwide. The critical caveat, however, is the profound secrecy maintained by countries like China and North Korea, where true numbers are believed to be vastly higher than any official or estimated figures suggest. This lack of transparency is the first and most fundamental layer of the horror, transforming the death penalty from a public act of justice into a clandestine act of state power, leaving families in agonizing limbo and preventing any meaningful public accountability. Chapter 1. The Black Box of China, Secrecy on an Industrial Scale. China stands as the undisputed epicenter of capital punishment, executing more people annually than all other countries combined. Yet, understanding the full scope is like grasping at smoke. The Chinese government treats execution data as a state secret, refusing to release official statistics. This policy of extreme secrecy was highlighted in a 2014 Amnesty International report, which emphasized the urgent need for China to reform its death penalty system, noting that the practice is kept under a shroud of secrecy, with no public details or even official confirmation of when these executions take place. Methods and the Machinery of Death China primarily employs two methods of execution, the firing squad and lethal injection. While lethal injection is increasingly promoted as a more modern and humane method, its implementation is fraught with the same secrecy that characterizes all aspects of the Chinese justice system. The firing squad, however, retains a particularly brutal and symbolic finality. In this method, the prisoner is typically tied to a stake or a chair, and a squad of marksmen aims for the heart or the back of the head. The intention is efficiency, but the reality is a visceral, violent end that strips away any semblance of dignity. There are no public records detailing how many individuals meet their end this way each year. For the families, the process is a black hole. They are often notified only after the fact, if at all, denied the opportunity for a final farewell or even the chance to reclaim the body for a proper burial. This cold, impersonal efficiency makes death feel less like a legal sentence and more like an administrative disposal. The international dimension and political leverage. The use of the death penalty against foreign nationals adds another layer of complexity and controversy. These cases often involve individuals caught in the web of China's notoriously strict anti-drug laws, or those entangled in politically sensitive situations. The execution of Akmal Sheikh, a British national, in 2009 sent shockwaves through Europe. Sheikh, who suffered from severe bipolar disorder, was convicted of drug trafficking. His family and legal team argued he was mentally ill and manipulated by a criminal gang, yet their pleas for clemency were ignored. His case became a stark reminder that within China's opaque legal system, extenuating circumstances often hold little weight. Similarly, the 2015 execution of Andrew Chan, an Australian national and a member of the Bali 9 drug smuggling ring, underscored the finality of China's stance. Despite high-level diplomatic appeals from Australia, Chan was executed by firing squad. The secrecy surrounding the date and time of his execution meant his family spent years in a state of perpetual dread, a psychological torture in its own right. These cases demonstrate how the death penalty can become intertwined with diplomatic posturing and assertions of national sovereignty. Chapter 2: Vietnam, Midnight Executions and the Silence of the State. Moving southward, Vietnam presents another model of state-sanctioned killing characterized by profound secrecy. Like China, Vietnam maintains a broad range of capital offenses, with drug trafficking being a particularly common charge that carries a mandatory death sentence. The most disturbing feature of Vietnam's system is the timing and clandestine nature of executions. They are frequently carried out in the dead of night, with no prior announcement to the public, the media, or even the prisoners' families. This practice was tragically illustrated in the case of Nguyen Duc Huy, sentenced to death in 2016 for drug trafficking. His family was not informed of his impending execution. They learned of his death only after it had occurred. This policy of post-facto notification is a profound cruelty, robbing loved ones of the chance to say goodbye and adding a layer of traumatic shock to their grief. The Vietnamese government maintains tight control over all information related to death row, preventing independent media scrutiny and ensuring that the realities of the execution process remain hidden from public view. This lack of transparency fosters an environment where procedural abuses and injustices can flourish unchecked, making the already grim reality of capital punishment even more terrifying for those caught within its grasp. Chapter 3: Japan, the psychological torment of solitary and secrecy. In stark contrast to the sheer volume of executions in China, Japan's use of the death penalty is low and methodical. Yet, many human rights advocates argue that the Japanese system is uniquely cruel in its psychological design. The method of execution is hanging, but it is the process leading up to it that constitutes a form of prolonged mental torture. Death row inmates in Japan are held in strict, prolonged solitary confinement. They are isolated from other prisoners and have severely limited contact with the outside world. Most devastatingly, they are not informed of their execution date until the very morning it is to be carried out. This means that for years, even decades, prisoners live in a state of constant, agonizing uncertainty. Every footstep outside their cell, every jingle of keys could signal the end. This death row phenomenon, the intense mental suffering caused by the conditions of confinement, and the anticipation of execution, is considered by many psychologists to be a form of torture. The case of Iwao Hakamada stands as a terrifying monument to the potential for error and cruelty within this system. A former professional boxer, Hakamada was convicted of a multiple murder in 1966 and sentenced to death. He spent 48 years on death row, much of it in solitary confinement, maintaining his innocence throughout. He was eventually released in 2014 after a court ruled that key evidence against him had likely been fabricated by police. Hakamada's case is extreme, but it illuminates the abyss. A man lived for nearly 5 decades not knowing if each day would be his last, only to be proven innocent after his life had already been effectively destroyed. His story is a powerful indictment of a system that prioritizes finality over fairness and inflicts profound psychological damage long before the noose is ever deployed. Chapter 4: Indonesia and Singapore. The death penalty as political theater and deterrent. In Southeast Asia, the death penalty takes on a distinctly public and political character, often framed as a necessary tool in the war on drugs. Indonesia's firing squads and Global Defiance Indonesia catapulted into the global spotlight in 2015, when President Joko Widodo's administration executed 14 drug convicts by firing squad, including foreign nationals from Brazil, Nigeria, and Australia. This event was not a quiet administrative act. It was a calculated political statement. President Widodo explicitly stated that he would reject all clemency appeals for drug traffickers, framing the executions as a matter of national sovereignty and a crucial deterrent against a drug emergency. The method itself, the firing squad, is a brutal and theatrical spectacle. Prisoners are tied to a post, often with a target over their heart, and executed by a team of marksmen. In some cases, a blank is included in one of the rifles, a macabre practice that allows each member of the squad to cling to the faint possibility that they did not fire a fatal shot. The prisoners are typically given only 72 hours notice, a devastatingly short period to make peace with their fate and say their final goodbyes. The case of Mary Jane Veloso, a Filipino woman convicted of drug trafficking, further illustrates the international and political complexities. She was granted a last-minute reprieve due to evolving circumstances in her case in the Philippines, but the fate of others, like Australians Andrew Chan and Mayuran Sukumaran, executed in 2015, demonstrated Indonesia's willingness to face international condemnation and strain diplomatic relations to assert its hardline stance. Critics argue that these executions serve less as an effective crime deterrent, a claim for which there is little empirical evidence, and more as a populist tool to project an image of a strong, resolute government. Singapore's unyielding stance. The ritual of hanging. Singapore maintains one of the world's most rigid and uncompromising capital punishment regimes, with mandatory death sentences for offenses like murder and certain drug trafficking crimes. The method of execution is hanging, a practice carried out with clinical precision at Changi Prison at dawn on a Friday. The Singaporean government defends its policy vehemently, arguing that it is a vital deterrent that has kept the country safe and largely free from drug-related crime. However, human rights organizations and academic studies have repeatedly challenged the validity of this deterrent effect, pointing out that drug use is driven by complex socioeconomic factors largely unaffected by the threat of execution. The 2015 execution of Ko Jabing, a Malaysian national, became an international cause célèbre. Jabing was convicted of murder during a robbery, a crime that did not involve premeditation. His case sparked a lengthy legal battle and appeals for clemency, including from the Malaysian government. Despite this, Singapore proceeded with the hanging. The case highlighted the inflexibility of Singapore's laws and the state's absolute power to take a life, even in the face of compelling arguments for mercy and international appeals. The swift and certain finality of the gallows serves as a chilling reminder of the state's authority, instilling a deep-seated fear that critics argue is disproportionate and inhumane. Chapter 5. North Korea, execution as a tool of totalitarian control. At the extreme end of the spectrum lies North Korea, where the death penalty is fully weaponized as an instrument of total political control. In the Democratic People's Republic of Korea, DPRK, executions are not merely for common crimes, but are routinely used to eliminate political rivals, suppress dissent, and terrorize the population into absolute submission. The concept of a fair trial is non-existent. Many executions are carried out summarily, without any legal process. The methods reported by defectors and NGOs are grotesquely brutal, designed to maximize terror. While firing squads are common for public executions, there are persistent and credible reports of executions by anti-aircraft guns, flamethrowers, and even hanging in public squares. These events are often staged as public spectacles, compelling attendance from citizens to witness the fate of those who dare to challenge the regime. The 2013 execution of Jang Song-thaek, the powerful uncle of leader Kim Jong-un, is a prime example. After a swift and secretive trial, Jong was convicted of treason and summarily executed by firing squad. His very public purge and elimination sent a shockwave through the North Korean elite and the population at large. A stark message that no one, no matter how highly placed, is safe from the leader's wrath. In North Korea, the death penalty is the ultimate tool of political hygiene, used to cleanse the party of perceived disloyalty and to maintain the Kim dynasty's absolute grip on power through a culture of pervasive fear. Conclusion: the cycle of violence and the flicker of hope. The most horrible aspect of the death penalty in Asia is not found in any single method, be it a bullet, a noose, or a lethal injection. The true horror is a composite. It is in the systemic secrecy that denies dignity and accountability. It is in the psychological torment of indefinite waiting and solitary confinement. It is in the irreversible nature of a punishment that, as the case of Iwao Hakamoto proves, can claim the innocent. And it is in the cynical deployment of state killing as a tool for political consolidation and international posturing. The death penalty in these contexts does not solve the root causes of crime: poverty, inequality, lack of opportunity, mental health issues, or political oppression. Instead, it perpetuates a cycle of violence, suffering, and fear. It teaches that the power to kill is a legitimate expression of state authority, a dangerous precedent in any society. Despite the grim panorama, there are flickers of hope. The global trend is undeniably moving towards abolition. Nations like Nepal and Mongolia have abolished the death penalty, and in other parts of Asia, there is a growing and vibrant debate, fueled by civil society groups, lawyers, and human rights advocates. The international community, through bodies like the United Nations, continues to apply pressure, framing the abolition of capital punishment as a fundamental human rights issue. The path forward is long and fraught with political resistance. However, by continuing to shed light on the dark corners of death rows across Asia, by amplifying the stories of the condemned and their families, and by relentlessly advocating for transparency and justice, we contribute to a future where justice is measured not by the lives we take, but by the dignity, fairness, and humanity we uphold. Only by breaking this cycle can we hope to build legal systems that truly serve the cause of justice, without resorting to the very violence they seek to condemn.